Hi, I'm Texas attorney Dan Lazarine. I'd like to take a few moments to discuss with you something we've heard about in the news quite a bit lately, new pretrial intervention programs that exist in some counties throughout Texas. What exactly is a pretrial intervention program? Who qualifies for these programs, and what exactly does it mean? First of all, how a defendant chooses to resolve his case is a decision that can only be made after an attorney investigates the case thoroughly, evaluates the evidence and the law, and then thoroughly discusses all of those things with his or her client. But for years and years and years, in situations where the state refused to dismiss the charge, a defendant had only a few options. One, plead guilty, try to work out some deal with the state, which usually involved a conviction on that person's record, or at the very least a deferred adjudication, which involved a lengthy probation, or go to trial and risk being convicted, potentially going to jail, a lot of other uncertainty there at a trial. And so there just weren't a lot of options. To remedy this and provide sort of another alternative, some district attorneys have come up with what they call pretrial intervention programs. And essentially what this is for a very limited group of people, usually first-time offenders who are willing to successfully complete a program and who can actually successfully complete that program. If that first-time offender accepts responsibility for certain types of offenses, a district attorney may allow them to enter into a pretrial intervention program. Now, what exactly does this program consist of? Generally, it's a lot like a probation. There's going to be supervision involved. There will be some sort of rehabilitation specific to each defendant. There may be community service and other classes involved. But the main feature of a pretrial intervention program is that at the end, if that person is successful, the case gets dismissed. And I think, as we know, and I've discussed elsewhere, if a case is outright dismissed by a prosecutor, it's eligible for expunction or deletion of records. So that's why these programs can be important and can be great for clients who are up against a very strong state case.